Good afternoon.
Good afternoon, my lords. I said I would turn to ground one, and that's what I will do. And it's important to have regard to how ground one has been put, because it's been put as how it's been pleaded, because it's been put in all submissions in a number of different ways. But ground one is pleaded, and and in which permission was given by Lord Justice Newey. Court was wrong to find that local authorities are required to make a further decision as to the ending of the main duty under Section 193, Housing Act 1996, and was therefore wrong to grant the claimant relief on this basis. Now, in the appellant's skeleton, that's put in a number of ways, but it includes a challenge to the judge's decision that there was not automatic ending of the duty. And so I am going to deal with that. Today it's been put partly as that, but also, and possibly more time was taken on that, on this concept of a prospective decision contained in the offer letter. So I will come to that. Our position on ground one is this. First of all, we say that there cannot be an automatic ending, and that the judge below was right about that, because for an automatic ending would be inconsistent with binding authority, with statutory interpretation, and indeed with policy and good administrative practice. So we say that there has to be a decision that all the elements that are set out at Section 1937AA to AC have been met. And given that at least one of those elements is acceptance or refusal, which can only happen post-offer, then that decision includes an evaluative judgment after post-offer and after the events that might amount to refusal or acceptance. If it is possible to have in the offer letter a review of the elements at Section 1937AA, excluding acceptance or refusal, then the appellant says it's possible at that point for somebody in my client's position to review not only the suitability of the accommodation, which everybody agrees that following the offer letter she was entitled to that review, but also to in respect of a decision that all the elements in the subsections are met. And we say, firstly, and I'll develop it, that that is not the ratio of Warsami and Ravichandran, which are the binding authority on this court. Secondly, that when you read those authorities as a whole, it's clear that there would have to be an invitation to the applicant to avail herself of such a review, to tell her that the review, the right to request a review is available, and there wasn't in this case. And even if it is possible for somebody in my client's position to request a review under B of the elements at Section 1937AA to 7AC, having received the offer letter, even if that's the case, a local authority would still have to make a further decision at the very least about the remaining element of subsection 7AA, i.e. whether there has been acceptance or refusal. Even if they were entitled at that point to confine themselves to saying, this is the only part of the decision that we need to make, we made everything else in the offer letter. And my client would have a right to request a review of that. And one of the points I want to make about the evaluative judgment of events post-offer is that acceptance or refusal isn't necessarily binary. It feels quite attractive to say, well, there must have been one or the other, and therefore the local authority was right and entitled as it did to set up, as it were, a concept of a deemed refusal if you don't arrive at the agent's office in Derby at 2 p.m. on the 15th of June. We will take that as a refusal. They're clearly entitled to do that, and it's the right thing to do because applicants might simply not respond at all. They have to set up that notion of a deemed refusal. But it can't be right that on Monday the 15th of January only one of two things could have happened. Either my client accepted it or she refused it, either explicitly or by failing to go to Derby. Because there could be scenarios, and I appreciate these are not the facts of this case, but my lords are interpreting the statute here, and that is applicable to all applicants, obviously, and all local authorities. But there may well be a middle position between acceptance and refusal, where an applicant had intended to accept, was ready to travel to Derby in accordance with the terms of the letter, and for whatever reason had been unable to do so. There may have been some dreadful tragedy overnight, the trains may not have worked, so she's neither accepted nor refused, and in those circumstances it's not good enough for a local authority simply to say our offer letter contained acceptance or refusal, set out that was the element of section 1937AA. So we don't even need to think about, it's clear that you have accepted or that you have refused. On my scenario, you've refused. She must have the right to challenge that decision. So let me develop that a little more, and I say that the judge was right in his conclusion at paragraph 85 that once the section 193 duty is accepted as being owed, the defendant, the local authority, must make a decision that it is at an end, that is that the statutory conditions necessary to bring it to an end have been satisfied.
Will you come to the statute itself in a moment?
I will. I was going to start with binding authority and then the statute, but
no,
I can
I'd
do
rather
it the
you
other way
started
around.
with the statute, if you wouldn't mind, because that's where we have to start.
So we have the statute at page 37 of the authorities.
Before we there are so many iterations of this. Which one are you coming to? Is it the 2012-2018 version?
The current one, yes.
Or is the one is that the last but one?
No, the current one at page 36 and 37, and it's operative from the 3rd of April 2018.
36, 37. Thank you.
Now, my client, of course, had applied prior to 2018 and prior to the amendments,
Right.
but not in terms of the amendments do not affect her in any way. So this is the appropriate statute, both for my client and for the current position. As I drew to my Lord's attention, parts of that are due to be amended by the Renters' Rights Bill as a result of the abolition of assured short-hold tenancies, including, of course, the Norton point that we've been concerned with.
Right.
And section 37 sets out all the elements.
Page
37, subsection 7AA.
Right, we're going back, because we're concerned here with circumstances in which the housing duty ceases.
Yes.
And there are a series of paragraphs which take us through the various possibilities, aren't there?
Yes. So indeed, we could go back to subsection 1, halfway down page 36, which says when the duty is owed.
Yes.
And then we can go to subsection 3.
Yes, that's I think where we start.
My Lord had in mind, I thought, yes.
Yes.
The authority is subject to the duty under this section until it ceases by virtue of any of the following provisions.
So what we've got on the face of it, I appreciate you have other arguments to make, but on the face of it, we've got a statute which says that it will tell us when the duty exists and when it ceases.
Yes.
Right.
And it does that, but what that doesn't, despite the wording of ceasing to be subject to the duty, which we can see not only in subsection 3, but beginning each of the 4 subsections which provide for ending of the duty, and that's subsection 5, subsection 6, subsection 7, and then subsection 7AA.
Yes.
So the wording is identical at the beginning of each of those subsections.
Right. So again, on the face of it, I don't mean to cut across any other arguments that any of the parties may have, but this looks to be a code that explains to us when the duty starts and when it stops.
Yes. But that wording doesn't mean that it happens automatically. For 2 reasons. One is binding authority, which I'm going to come on to. But the second is because a number of evaluative judgments need to be made by the local authority. So the local authority needs to decide, if we look at 7AA, 1, that the applicant has been informed in writing of the matters mentioned. It then
Yes, I know you want to get to 7AA. I just want for the moment to see what the structure of the section is by reference to each of the subparagraphs.
Yes, so we'll go back to 5.
Yes, so
5 is where the local authority ceases to be subject to the duty, where the applicant has been informed by the authority of the possible consequence of refusal of acceptance and of the right to request a review of the suitability of the accommodation, where the applicant refuses an offer of accommodation and the local authority is satisfied that that offer was suitable for the applicant, for the applicant.
Right, and how does that fit into our case?
Well, that is an offer of accommodation made under section 193 duty.
So it applies to our case.
It is the. It doesn't apply. It's not the offer letter of the 11th of June.
No, I'm just concerned with where within this large statutory framework Mrs. Bano fell, and did she fall under 1935?
No, she fell under 7AA.
Because the difference between 5 and 7AA being
Mrs. Bano, if my lord turns back to page 36 in subsection 2, unless the authority refer the application to another local housing authority, they shall secure that accommodation is available for occupation by the applicant. And Mrs. Bano had that in the form of the accommodation at 8 Bing Close that she was occupying at the time that the offer was made to her. So that was what's colloquially referred to as temporary accommodation.
Yes.
And subsection 5 provides for the circumstances where an applicant refuses an offer of temporary accommodation. And we know that because of B at subsection 5.
It's the Part 6 or private rented sector.
Yes. So it can't...
It's not 5 because of B. Right,
yes.
I've got that.
Yes, B means it is not, again, what is colloquially referred to as permanent.
Right, so not 5, and it's not 6.
So Mrs. Bano is not 5, and Mrs. Bano is not 6. And Mrs. Bano is also not 7, which is where the applicant, having been informed of the possible consequence of refusal or acceptance and of her right to request a review of the suitability of accommodation, refuses a final offer of accommodation under Part 6.
Right, and the reason on your case why it's not 7?
It was not an offer of accommodation under Part 6. It was not a secure or assured tenancy provided by a local authority or housing association. And that's made clear. So there is no question that it was 7AA.
Right, Thank you. I'm sorry for
No.
pulling you back, but it's
No.
just to understand exactly how 7AA fits in. It's very helpful.
It's always helpful. And legislatively, my lord, the original framing of section 193 was that applicants in temporary accommodation would be given an offer of Part 6 accommodation,
Yes.
secure or assured tenancy. Over the years, the possibility of an offer of private rented sector accommodation came in
Yes.
in a number of different ways. Initially, they were free to refuse it if they wanted. Since the Localism Act, then a private rented sector offer, being an offer of an assured short-hold tenancy for at least 12 months, can bring the section 193 duty to an end, provided all the elements that subsection 7AA through to 7AC are met.
Right. Thank you very much. Now, 7AA.
So we are in 7AA. And what the local authority has to decide, let me put that another way, the elements that must be met in order for the duty to have come to an end, and that was set out at paragraph 70 of our skeleton, which has been referred to, that the applicant must be informed in writing of the matters mentioned. The 3 matters mentioned are then at 7AB, and we know that in this case 7AB6 was the information contained in the offer letter was defective. And then if we go back up to 7AA...
Say that again, sorry.
Sorry.
In order to qualify for the end of its duty under 7AA, they have to make the offer and inform of the matters in writing, the matters in 7AB.
In order for the elements to have been met,
Yeah.
the local authority has to set out in writing
Yes.
to the applicant the 3 matters in 7AB. They have to make her a private rented sector offer,
Yeah.
which itself has to comply with the 3 elements at 7AC. It has to be an assured short-hold tenancy made by a private landlord to the applicant in relation to any accommodation which is or may become available for the applicant's occupation. It's made with the approval of the authority in pursuance of arrangements made by the authority with the landlord with a view to bringing the authority's duties to, under this section to an end, and the tenancy must be a fixed term tenancy for a period of at least 12 months, and this one was 24 months. So it has to comply with that.
Yes.
And then when we go back up to 7AA, the applicant must either accept it or refuse it, or refuse the offer. And I've made the point that there may be scenarios, unusual, of course, but there may be scenarios where an applicant actually has done neither of those things, even though the concept of a deemed refusal was set up in the offer letter.
Right. And remind, please, because I was just writing something down. The matters in default here, you say under 7AB, were which of A, B or C?
It's little c, the effect of section 195A of a further application to a local housing authority within 2 years of acceptance of the offer.
Any problem with A or B?
No.
So, in this case, as it happens,
it was effective for that reason.
A was complied with, little
Yes.
b was complied with.
And C was
So-
not.
Was that not complied with in full? It was complied with in part. Is that the discussion that we had with Ms. Simone earlier on as to what was and what
The
wasn't?
full effect of section 195A was not set out. The effect of section 195A1 was set out. The effect of section 195A2 was not set out. And the Court of Appeal in Norton found that a failure to set out subset 195A2 was therefore not a fulfilment
Right.
of 7AB little c.
So, accepting what Norton says, 7AB little c, in this case, where, as it were, we're not going to Derby, is rather in the outer atmosphere. What could have been said there, the effect of a further application within 2 years of acceptance of the offer.
The statute says
yes.
that a local authority, which is a public authority, must comply with the law, has to, that those elements must be met in order for the duty to come to an end. Right. There is no room in the statute for a local authority to decide that on the particular facts we don't need to provide a particular piece of information or notification.
So one might well think that it's sensible of the bill to get rid of this requirement, but the fact is it was there.
The fact is it's there, and the bill gets rid of the requirement because the bill is repealing section 195A, not because it necessarily disagrees with Norton, who knows whether that's also the case. It's not been said in Parliament, but section 195A is repealed in the bill, because, well, it will be repealed in the bill, because assured short-hold tenancies are to be abolished, and fixed-term tenancies are to be abolished, and therefore there were also amendments to 7AC little c, because applicants who are being given a private rented sector offer under 7AA, once the bill comes into force, will be given an assured tenancy by a private landlord that will be periodic. And therefore, section 195A, which refers to a reapplication within 2 years, it's thought, Parliament seems to think, is unnecessary because the assured tenancy will not obviously end within 2 years, because it won't be a fixed term tenancy. I've not explained that terribly well. But that's the repeal of little c is not necessarily because of Norton, certainly not on the face of the bill or indeed in the explanatory notes. It's because section 195A is being repealed.
Yes, I see.
And those are the elements that are set out at 7AA through to 7AC. But there are, of course, additional elements, and they start at 7F, halfway up, page 38. The local housing authority shall not, AB, approve a private rented sector offer unless they are satisfied that the accommodation is suitable for the applicant and that subsection 8 does not apply to the applicant. So that's an additional decision that the local authority have to take on suitability. And that, of course, is often the big decision. And it's often the decision that applicants want to challenge most frequently. And suitability obviously has a number of aspects which needn't concern us today, but that's one of the reasons why paragraph 70 in the skeleton argument set out those elements as it did, to make the point that there are a number of aspects. One, on suitability. Two, particularly on private rented sector offers, because there's a statutory instrument providing for another 10 matters to be satisfied in respect of private rented sector offers. So there is a detailed set of considerations for suitability of private rented sector offers. And then the last thing is subsection 8, because the local authority have to be satisfied that subsection 8 does not apply. And subsection 8 applies to an applicant if the applicant is under contractual or other obligations in respect of the applicant's existing accommodation, and the applicant is not able to bring those obligations to an end before being required to take up the offer. Now, most of those don't apply to my client. What applied in reality was a suitability issue, which he never requested a review, and what we also know applied was the Norton 195A point. But all of those elements have to be satisfied for there to be a lawful decision. And some of those elements involve something of a tick box exercise. Was she informed of the possible consequence of refusal or acceptance? and that she had the right to request a review, etc. And some of them are evaluative judgments.
But what is it being? Could you just crystallise, rising out of the point my lord made earlier on? What is the significance of it having to be a lawful decision, as opposed to it just being a decision?
Because local authorities should be acting lawfully.
That's not really an answer, is it? Because if that was always happening, then there wouldn't be such a thing as judicial review.
Well, sorry, I didn't mean to interrupt you.
No, I was interrupting you. So, why are we concerned whether it's been a lawful decision or not? Because if it's a decision, you challenge it. If it's not lawful, you succeed.
Well, because the statute sets out the elements that must be met. It must be a principle of legality that the starting point is that public authorities are expected to comply with.
But with a maze of legislation of this sort, there will clearly be cases in which even the best intentioned local authority will fall at one or other of the fences. They're not going to get a clear round every time.
Yes, but they should be trying to.
Yes, but this doesn't answer the question as to why are we concerned to ensure that every single box, as you put it, has been ticked, rather than just seeing when a decision has been made, good, bad, or indifferent.
Well, because the statute provides that the duty only ceases, and I'm aware that there's an issue about whether that's automatic or there's a decision, obviously is the crux of my submissions, but that the duty only ceases when all of these elements have been met. So not only would there be a decision, if there was a decision that the duty has ceased, even though we haven't told her about the possible consequence of acceptance or refusal, not only would that be an unlawful decision, but as a matter of law, the duty would not have ceased. And the onus would be on the applicant then, as my Lord Peter Jackson made the point, to bring an appropriate legal remedy. But the whole structure of the Housing Act is not that local authorities should make decisions which applicants then spend a great deal of time, energy, and indeed public resources challenging by coming to court. The whole structure of the Housing Act is that local authorities should be making decisions that either start a duty, decisions are you in priority need and so forth, or end a duty, or indeed a myriad of other decisions that they have to make under the 96 Act.
Can I just
it's
ask...
not predicated on the basis that every time a decision is made, somebody will be rushing off to court to try and challenge that.
Can I check a specific point? Section 202 says that there's a right to request a review of all sorts of decisions. Presumably those decisions can be flawed decisions.
Yes, there could be two sorts of decisions. There could be decisions where the applicant just disagrees with the factual evaluative judgment. I am in priority need. And there can be decisions where the applicant is saying this is flawed legally. Yes.
So in that context, decision doesn't mean just lawful decision, it means decision.
But of course, and this partly goes against me, the word decision is not at section 193. It ceases to be subject to the duty.
Yes.
So the way 193 is structured is that there needs to be these elements before the duty ends.
Yes.
And so, and this is why we're in this judicial review, if the elements are not met, then the duty has not ended.
When is it convenient? I just want to ask one thing. Leave aside the point about whether there has to be a decision. Just
Yes.
Looking for the moment at what you, I think, accurately described as the elements that have to be met to satisfy
Yes.
in order for the state of affairs to come to pass. My initial reading of 7AA was that there are really three things that have to happen before the duty comes to an end. And again, putting on one side whether there has to be a decision about these, just three things that have to happen. One is there has to be a private rented sector offer.
Yes.
And that's defined.
Defined at
So
7AC.
if it doesn't comply with the defined criteria, it's not a private sector rental.
Yes.
The second is that the applicant has to be informed in writing of the matters mentioned in 7AB.
Yes.
And as we know from Norton, and it's obvious anyway, if those things aren't done, then it doesn't, that criterion is not satisfied. And the third is, I can put it this way, the offer is either accepted or refused.
That's right, but there are the additional elements that the private rented sector offer must not only comply with 7AC, but it must be suitable.
Well, that was my question. The definition of a private rented sector officer does not include suitability. What the section says about suitability is that the local authority shall not approve a private rented sector offer unless they're satisfied the accommodation is suitable.
Yes.
That presupposes that you can have a private rented sector offer within the statute, even though the accommodation isn't suitable. Now, I don't understand quite how this works, but it seems that this is designed to divert disputes about whether accommodation is suitable into a different pot from the criteria that leads to the cessation of the duty. Am I wrong about that?
No. Well, partly, if I may say, put it that way.
No, I mean, it's a completely open question. I don't mind.
No,
being told
I
I'm
understand
wrong.
that, and I'm replying in the same spirit. The first point to make is that the suitability requirement applies to the approval of the private rented sector. I think my lord made
Yes.
that point.
If it's not suitable, or they don't think it's suitable, then it wouldn't be a lawful decision. But it doesn't follow that it.
So a private rented sector offer, going up to 7AC little b, an offer is a private rented sector offer if it is made with the approval of the authority in pursuance of arrangements made with the landlord with a view to bringing the authority's duty. So that suggests a two-stage process, which probably happens, I'll defer to Waltham Forest, but probably happens very quickly, but a two-stage process that the local authority approves a private rented sector offer, and in order to, before they make it, and in order to approve it, they must be satisfied that it's suitable. That's part of the answer. There's a second answer, which is at section 206. Give me a moment, which is page 79. And subsection 1, a local housing authority may discharge. Now, discharge is a very difficult word. It's used in part 7 in two ways. One is in the meaning of performing the duty, and the other is in the meaning of bringing a duty to an end. And the Court of Appeal in Godson and Enfield, which is not before you, but we quote it in our skeleton, they make the point that this word is used interchangeably. A local housing authority may discharge their housing functions under this part only, and I emphasise that, in the following ways: an ABC, and it's three different ways of securing accommodation. But in each of A, B and C, the word suitable is in front of the word accommodation. In other words, an offer of accommodation that is made under any of the subsections under section 193, or indeed any of the other duties, must be suitable. And that is well-established law. Now, a local authority can, and applicants say they frequently do, make an offer of accommodation that is not suitable. And where there is a dispute between a local authority and applicant about suitability, we have that review mechanism, that's section 2021F and G. And I'll come back to your point about hiving off in the two decisions in a moment. But we also know from authority in the Court of Appeal and the Supreme Court in the last 3 years that a local authority which provides unsuitable accommodation, where it is agreed between the local authority and the applicant that it's unsuitable, is in breach of its statutory duty. That a applicant's remedy about that is to bring a claim in judicial review for a declaration that the local authority is in breach of its statutory duty under Part 7. And the Supreme Court, in the case of Iman and Croydon, considered the circumstances in which not only a declaration would be made by the administrative court, but also a mandatory order requiring the local authority to secure suitable accommodation. And those two cases are called Al-Kundi and Birmingham, and then, which was in the Court of Appeal, and then Iman, I-M-A-M, and Croydon in the Supreme Court. So there is very clear authority that provision of unsuitable accommodation, and therefore an offer of unsuitable accommodation, where it's agreed that it's unsuitable, would be a breach of statutory duty. Which is, of course, different to where there's a dispute. Now, my Lord's point about hiving off the two issues is section 202. And Ravichandra is clear about that the availability, that because we have the two provisions of 2021, B, any decision of a local authority as to what duty, if any, is owed to him. And then F, G, and indeed H, which refers to other subsections, any decision of a local authority as to the suitability of accommodation offered to him in discharge of their duty. I said discharge was used throughout, and it is a difficult word. Under any of the provisions mentioned in B or E as to the suitability of accommodation offered to him, as mentioned, section 1937, and G, which is the one that applies to us, any decision of a local housing authority as to the suitability of accommodation offered to him by way of a private rented sector offer within the meaning of section 193. Now, most disputes are about suitability, but the authority is clear that the issue of suitability can be raised under B as well as under G.
Yeah, understood.
Let me just, if I may, check my notes about statutory interpretation before I go on to binding authorities, because I do want to spend a...
Can you put, just before leaving the statute, could you just, as it were, put the template of the statute on top of what happened in this case, in order that we can understand your submission as to what the relevant effect of these statutory provisions was on what was actually going on here?
Yes. So if we go back to page 37, section 193. The local authority approved a private rented sector in Derby, which they considered to be suitable for my client. So that's 7F and 7ACB, and we agree that the private rented sector offer complied with 7AC. The local authority informed the applicant of the matters at 7AB, except that, as we know, in relation to little c, they were defective and unlawful about that. The local authority made the offer to my client, and my client refused it, either in the WhatsApp message, but we would say that clearly wasn't sufficient for a refusal, because the response to the WhatsApp message was the email of the 14th of June saying that the offer remained open, but certainly refused it by not travelling to Derby, because that deemed refusal was set up. My client knew that she had the ability to request a review about suitability, because that was in the offer letter. And as we can see, subsequently, she thought she had done through her daughter, and Waltham Forest decided that that was not a request review. That's not for today, not for this case, not for my lords. What my client did not know, because she was not informed, is that she also had the right to request a review under B, and of the decision that the duty had ceased. And in Ravichandran, they make it clear that for an applicant must be invited to avail herself of that review. In other words, she must know of the availability. And going on from the letter of the 11th of June and summarising the point I made before lunch, in none of the subsequent communications, including the 7th of October, not only are none of them a decision, but also none of them are setting out that she had a right to request a review, that the duty had ceased because, in the local authority's opinion, the elements had been met at 7AA. And so the defect, we say, is there was not a decision by the local authority that it had ceased to be subject to the duty. And because there was not a decision, my client did not have the opportunity to challenge that decision. And I do want to make a point about the importance of reviews, which is this, and it goes to my Lord's point about challenge by the applicant if a local authority were to make an unlawful decision, which of course at times they do. They don't intend to, but of course at times they do. And it's this, what the Housing Act does, quite unusually, is it sets up this internal system of review. So that the review has to be decided by an officer of the local authority who was not involved in the original decision, is therefore independent of it, is senior to the officer who took the decision, and so forth. Or it may be a contractor brought in from outside. And the review is a full reconsideration of all the facts, circumstances and law, usually at the date of the review decision. And that's something that has two effects. First of all, it is of a huge benefit to applicants, because one officer in Waltham Forest might say, I'm satisfied that Derby is suitable for you. But another officer, either looking just at the same facts or looking at representations that my client, an applicant, has made in response to the offer, takes a different view. And that's clearly a good thing. It's clearly right that applicants should have the right for somebody else to look at it and to consider all the facts. And it's additionally right, given that the legal remedies of challenge, which I mean the judicial remedies of challenge, the court remedies of challenge, are on a point of law, either through an appeal to the county court once a review decision has been made, sometimes where a review decision hasn't been made, has been requested and not made. And that appeal, section 204, is on a point of law. In other words, that the decision that is being appealed, there has to be something wrong with it legally. I'm sorry, I'm putting it in idiot's language, as it were. What it is not, in the county court is a review of the facts. And if the decision was not one that carries a right to request a review, then the route of legal challenge, of judicial challenge, is through judicial review, again on a point of law, and it's well known that the jurisdiction of the county court on the appeal on point of law is the same as that of...
What would have been the situation on your analysis in this case if Mrs. Bano had accepted the Derby property?
So if she had accepted, first of all, I say that the local authority would have had to then come to a decision that she had accepted. Probably a very easy decision. And that they would have had to make a decision to that effect.
So the local authority would have had to decide she had accepted, but they didn't need to tell her they decided that.
Well, that's the difficulty with the notification point. But certainly they had to make a decision to that effect.
I mean, what bluntly is the point of that?
Well, two reasons. One is that, as my lords know, there is a right to request review of suitability whether you've accepted or refused. So the safe thing, as Waltham Forest say to my client, is to accept and request that review. Secondly, she may, having thought about it, had advice, looked at the offer letter and realised that there were matters in the offer letter which she did want to challenge. I was not properly informed, whatever it might happen to be, that don't relate to suitability, so they're not a 2021G review, but she still wants to do that. And she might want to do it because she might accept and be delighted to live in Derby and not want to have anything more to do with Waltham Forest, that everything has come to an end. But she's made one offer of accommodation. These are very difficult circumstances always for applicants. They often don't like them, as is the case. So she might accept, because she effectively had no choice. The alternative was an ending of the duty and homelessness. But having then moved to Derby, received advice, looked at the letter again within 21 days, realised that the elements of the duty had not been made out and that she could request a review on that. And that would then be to her benefit, because if the review agreed that the elements of the duty had not been made out, 7AA would not apply, Section 193 duty would still be owed, she'd be living in Derby, but at some point she would receive some other offer.
Can I just ask you about the realism of all this?
Yes.
So an offer is made, the offeree accepts the offer.
Yes.
Now you say, and I quite follow why you say it, that where offers are rejected, it's at least common for local authorities to write letters saying we think the duties come to an end because you refuse the offer. But do local authorities really write letters saying the duties come to an end because you accepted the offer?
Yes, they do, and they should, and that's very clear from 193. We say,
and
they're very rarely subject to review,
yes,
for obvious reasons. But it's not impossible that an applicant, is having accepted, is still dissatisfied and might then review.
I mean, I quite follow that the applicant might still be dissatisfied and so might request a review on one basis or another. But it doesn't strike me as at all obvious that a local authority would say to itself, oh, we need to make a decision as to whether the duties come to an end in circumstances where the applicant has just accepted what had been offered and the letter had said, well, if you accept it, the duty's over. And that leaves me to worry that there must be lots of cases where actually on your case there are continuing duties, because although accommodation has been accepted, no one's written a letter saying that that brings the duty to an end.
Part of the difficulty for my lords is that there are a number of assertions about administrative practice in this court with absolutely no evidence whatsoever. And clearly we're not in a position to provide evidence about local authorities. In my skeleton, I point to examples of cases where, as it were, the two-stage decision, I'm using shorthand, is the offer and then the decision is made. None of those are acceptances. They are all refusals, or arguments about refusals, as in Nicoleve. But it's not unusual to see. That's probably putting it too high, but certainly letters saying that the duty has come to an end because of acceptance are written. It may well be that there are local authorities where they're not written, and that the effect of my Lord's decision in this case that will affect them. But I also say very clearly that on the basis that the words cease to be subject to duty in 193 require a decision because evaluative judgments are to be made, that applies to acceptance, because we can see that in subsection 6 there are two ways in which the duty can come to an end where types of accommodation have been accepted. Part 6 acceptance and an assured tenancy that's not an assured short hold. And then we have acceptance in section 193 7AA. And part of Waltham Forest's submission has been, and I'm probably paraphrasing, but along the lines of to require local authorities to make what they call a further decision, what I say is a necessary decision, would be a additional burden. An additional procedural requirement will inevitably add to the burden on local housing authorities. And we make the point that a template letter, which these letters invariably are, as the letter of the 11th of June is not a huge burden on local authorities. It's a fairly straightforward letter that they can produce after the acceptance or refusal on the 15th or the 16th of June in this case. It can deal with the matters that have already been set out in the offer letter, so it can deal with the final evaluative decision about whether there was acceptance or refusal. So it's not an onerous burden, we say, in the cases of refusals, and therefore not a particularly onerous burden in the cases of acceptance, even if it feels a little pointless, because there may be the case where it's not pointless, and that case is where an applicant has accepted but is dissatisfied and realises that there was not that the elements had not been met, and that she could request a review on that basis. And I'm sorry.
No, you hadn't finished. I'm sorry.
Well, it's one extra point. Insofar as since we've got on to practicalities, as the sending out of one more letter is an additional burden stretching resources, and we all accept how pressed local authorities are, there's no question about that. We say that is more than compensated for by the clarity that a letter saying our duty has come to an end for the following reasons, set out the elements that have to be met. You have a right to request a review under 1B. And at that point, the duty has ended on that day. The requesting a review does not extend the duty. And within 21 days, the local authority will know whether or not there is a continuing dispute, because the applicant will have requested a review, or not. On the 22nd day, they'll know that she hasn't. And then we have finality. And the local authority knows that the Section 193 duty has come to an end and there is no challenge to that. And we point to the facts of this case where such a decision was not, whether or not it was made internally, but was not put in writing. We don't have a decision on the face of it, which shows the subsequent confusion that can arise and administrative chaos, ending up with a judicial review claim. Whereas had there been a letter on the 16th of June, Mrs. Bano would either have requested a review with the decision that the duty had come to an end, or she wouldn't. And that would have been that.
But I can't understand how that would have made matters any different. She had the letter of the
11th of June.
11th of June, which was basically take it or leave it.
Yes.
And what I can't understand, I appreciate her personal circumstances.
Yes.
You know, she was lucky to have one of her children who was able to advocate for her.
Who was 15.
Yes. So I'm not at all unaware of the human circumstances that existed here. But, I mean, broadly speaking, it was a very simple story. If you want us to house you, it's going to have to be in Derby. And you can either accept it or not accept it. Now, obviously, one could quite see why she might have wished to refuse that offer, as she did. But what in the real world prevented her from challenging it? Well,
we know she didn't.
No, but I can see many reasons why she didn't, because she didn't have the benefit of solicitors by that stage. But I mean, at that stage, I mean, for my own part, I can't see any obstacle at all to her making a range of challenges to what happened.
No,
but what this is a case is about is why she didn't do so at the time, and whether that causes her a difficulty when she finally got round to doing so. You know, by which time many boats had sailed.
But it's not entirely about that, because my lord is right that, of course, she lost the immediate opportunity to request a review of suitability.
How do you mean she lost it? She didn't. She was
told
she could. She was told she could apply to review suitability. She didn't do so.
She didn't do so.
Right. She might have had various other remedies. I don't know, but at all events, this was a dispute which ought to have been resolved in 2000.
Yes, and she could have done so through 2021G, and she was informed of that, about suitability. Yes,
and that was her complaint.
But as it happens, she had, as it happens on the facts of this case, I mean, yes, that's Mrs. Bano's complaint, but on the facts of this case, the full elements of section 1937AA have not been met because of Norton. And for
but she didn't.
She didn't know that.
No, she didn't know that at that time. It was open to her, at least theoretically, to have brought that argument, but she didn't.
But that's the second point, because she didn't have a letter saying we have ceased to be subject to the duty, and you have a right to request a review of that. So she was not invited to request a review under B that the duty had ceased. She was invited very clearly in the 11th of June letter to one type of review, yes, which was about suitability.
So this turns, doesn't it, on? I mean, you helpfully went through at my invitation how what happened in this case fitted with your helpful account of the statute.
Yes.
And you said that the defect was that there was not a decision by the local authority that it had ceased to be subject to the duty.
And there's the defect.
Now, we know what you have to do to cease to be subject to the duty.
Yes.
But we're not concerned about it. This is not a law exam. It's a challenge to administrative action. And so in terms of resolving this in our own minds, we have to consider whether, in fact, there had been a decision by the local authority that it had ceased to be subject to the duty. I mean, it doesn't, as it seems to me at the moment, matter whether the local authority was right, wrong, or a bit of both.
Well, part of the local authority's case is that there is automatic ending.
Yes.
And
so whether, for whatever reason, it ceased to be subject to the duty.
And I do need to address that.
I understand that, but at the moment, I don't see where the statute requires that the decision by the local authority that it was subject to the duty was correct. That's my difficulty with with trying to put the template of the statute on top of what happened here, because Mrs. Bano knew that she was being offered something that she found highly unattractive. Maybe.
Yes.
And her remedy, as was pointed out to her, was to take action on it.
Which she didn't do.
Which she didn't do. And so the question then for us is whether she's allowed to
anyway.
do that 2.5 years later. And as a result of some completely happenstance and on the facts of this case, defect in paperwork.
And that's a happenstance, yes, and that's to a certain extent that's confusing the issue.
Yeah.
But we say that the defect is the failure to make a decision in June 2020, not in May 2023, but in June 2020. Clearly, if in May 2023 the response to our representation...
Not Norton, it's the non-decision.
It's the non-decision. And we say that it does matter. Firstly, because we say cease to be subject to a duty means that there has to be a decision, because it involves coming to conclusions about things that involve evaluative judgments, as well as the tick box. And secondly, that the review of suitability is one thing, but it is not enough, and that both Wasami and Ravichandran make it clear that applicants in this position, who are, both parties have compelling cases about their circumstances, the council and the applicant, but applicants in this position who are given one offer, take it or leave it, short period of time, Thursday to Monday, to make their mind up, that it is both the right interpretation of the statute and the correct policy in terms of good administration, that they should have 2 bites of the cherry potentially, 1, the suitability review, and 2, the 2021B review, in which, as we know from Ravichandran, if they didn't use the first review, they can raise suitability on the second review.
Well, thank you very much. I know you were going to structure your submissions in a different way by referring to the authorities, and so I'll get out of your road.
If I may, I will. Can I make one more point on statutory interpretation? 2 more points. I'm sorry. The first, and I don't need to develop it because it's made clearly in the skeleton argument, is that Waltham, as we know, decides that a decision that where duty has ceased under section 193, that there is a right to request a review under 1B. So we know that, and that obviously was always the case, but it was explained by the Court of Appeal in 2000, 24 years ago. And since then, Parliament has quite extensively amended Part 7, and we've calculated 9 amendments to section 193 and 7 amendments to section 202. And so if Wasami is wrong on the decision leading to a review under B point, and if Parliament thought that, they have plenty of opportunity to amend either or both of section 193 and section 202 to make that clear. And Parliament has chosen not to. The other point about Wasami, which I am going to go to in a moment, is this. If there is a right to request a review, which there clearly is, there has to be a decision. And we find that in 2021B, which is page 68. And 2021B, an applicant has the right to request a review of any decision of a local housing authority as to what duty, if any, is owed to him under various sections. And the sections have been amended since Wasami, but those words, decision of a local housing authority as to what duty, if any, is owed to him, have not been amended. So there has to be a decision. Despite the difficulty in the judgment about notification, we know that the review can only be made once there is notification, because we know that from 2023, halfway up page 69, which is that the 21 days in which to request a review begins on the day on which he is notified of the authority's decision. And so for an effective review of the duty coming, the duty that the local authority ceasing to be subject to a duty under section 193, then the wording of 202, which Parliament has left undisturbed, says that there is a decision. And there has to be a decision conceptually, as well as because of the words of the statute, because otherwise there could not be a review of such a decision. There has to be something you review. You can't have, it can't just be anomalous. So I make that point about statutory interpretation. And I make the point about notification that whilst I agree that it is difficult to have the concept that a decision can be made without a requirement to notify it, that the Deputy High Court judge was right when, having concluded that there was not an obligation to notify, which is at which is at paragraph 51, page 73 of the core bundle. He goes on at paragraph 52 to say the lack of an express notification requirement is not an answer to the issue at the heart of Ms Bano's claim. The defendant did not in fact make a decision that the main duty was ended through its chosen PRSO route, and such a decision was necessary to make the main duty, and the statutory conditions for the main duty to cease were not satisfied. So the Deputy High Court judge makes a very clear distinction. He does not say, as Mr Mullin's skeleton argument says, well, if there's no notification, what benefit is a decision to an applicant? And my answer to that is that the Deputy High Court judge was right to say there still must be a decision. But I agree, it's difficult without an obligation to notify for an applicant then to request a review under 202.
I mean, I wonder actually whether the position for such an applicant may not be so bad, because if a decision isn't notified, time won't run for 2023.
Well, quite. And if on the 7th of October there had been a decision that said there was an offer made on the 11th of June, the decision, the duty has ceased to be owed for and set it out, given the reasons, you have a right to request a review under B, then that would have been lawful. And that's not unusual. My Lord asked about practice on the ground. It is not at all unusual for decisions that end duties to be made weeks, months after an offer has been refused. It can be confusing for an applicant, but it is perfectly normal and perfectly lawful. And it does give the applicant the chance at that point to say, this is what I would have said. So, can I just deal with Wasami? And I'm going to deal with it on the basis that my learned friend has taken you through it. And it is tab 10 in the Bundle of Authorities, page 238. And what that was a refusal of a Part 6 offer, so it was under section 1937 in its original iteration. And at that time there was no private rented sector offer, there was no 7AA. And we know that there were two decisions. The page 244, page 702 of the report, at F, in the second sentence, the applicants notified the right authority in writing that the offer was refused. And then between G and H, there is the difficultly worded decision by the local authority, which was a decision that the duty had come to an end under section 193. And Lord Justice Chadwick says at page 245, paragraph B, there are a number of criticisms that could be made of the way in which that letter is expressed, but the thrust is clear enough. The council was intending to treat the refusal of accommodation offered under Part 6 as a ground for bringing the duty imposed by section 1932 to an end under the provisions of section 1937. If that duty were to stand, then the authority would no longer be under any duty under section 1932 to secure that accommodation was available for occupation by the applicants. That would be the effect of section 1937 in the circumstances which I've described. And the reason why my learned friend drew attention to the words "was intending to treat," and one can see why Lord Justice Chadwick used that phrase, because the ending duty decision that he's considering is more generous, one might say, to many ending duty decisions in more recent years, because it was a decision that the duty was ended, but there was still the opportunity for the applicants to reconsider their refusal and change their mind. And that's, these days, it's very unusual to see that from a local authority when they notify that a decision has ended. They don't keep the offer open. Indeed, there is case law on whether or not they should keep the offer open, and the answer is no. So that was more generous in those days than one sees now, and that's where the words "intending to treat the refusal" come in. And then the applicants requested a review, and they had a review. So the local authority didn't at that point take the point they subsequently took in the county court. And at the bottom of page 245, the result of the review was that the local authority was confirming a decision that there was no longer any duty owed to the applicant. They appealed to the county court, and at that point, Hounslow took the point that there was no jurisdiction for the county court because, in fact, they had no jurisdiction to undertake a review. The jurisdiction of the county court under section 204 only arises either in respect of a review decision or where there has been a request for a review and the review has not been carried out. And Hounslow's position was section 202 did not provide for a review of the duty to come to an end. And the county, His Honour Judge Oppenheimer, found that that was right. And Lord Justice Chadwick, giving the majority judgment, found that that was wrong. And from halfway down F at page 246, in my view, that approach, the approach being that B only applied to duties as to decisions as to whether duties were owed, not that they had come to an end, failed to give due weight to the width of section 202(1)(b). The right to request a review arises under that paragraph in respect of any decision of a local authority as to what duty, if any, is owed under the various sections. The first question, as it seems to me, is whether a decision by a local authority that it no longer owes a duty because some event has occurred which has caused an existing duty to cease is a decision as to what duty, if any, is owed. If so, then the second question is whether a decision as to whether those events have occurred is also within the phrase. The answer to that first question, to my mind, is plain enough on the language that is used. It's plain that section 202(1)(b) is directed at least to the question whether a duty arises. The phrase "any decision as to what duty, if any, is owed" reflects the word in section 1841(b), so that's the first set of decisions that are made, and he deals with that, but he goes on at the top of page 247, but although the paragraph plainly applies in that case, the language is apt also to apply to a decision that a duty once owed is owed no longer. And my lords will have read that, the rest of it for themselves. And he makes the point at D, further down. He says that if a phrase, any decision within section 212b includes decisions as to factual scenarios which must exist for any duty or any particular duty to have arisen, I can see no reason why that phrase should not apply to decisions as to the existence of events or factual situations which, if they have occurred or do exist, will have the effect that the duty ceases to exist. The words are plainly wide enough to cover that case. And one of the reasons for that was because section 2021F at that time provided a request for review of suitability of accommodation provided under section 193, but not of part 6 of the suitability of part 6 offers. Now, my learned friend said that the words at page 245b, where Lord Justice Chadwick characterised the decision letter, not the review letter, but the decision letter, that the council was intending to treat the refusal of accommodation as a ground for bringing the duty to an end, as therefore a prospective decision. And I say that that is reading far too much into it, that whilst that decision is, as I say, much more generously worded than decisions one sees nowadays, because the offer remains open and the applicants are being pressed to take it. It's the wording, if one looks at the wording at A, the council is of the opinion that the offer is suitable for you and your household, and by making it to you, the duty accepted towards you following your homeless application has been fully discharged. Not will be, but has been.
What's the distinction that you draw between the letter in that case and the August email, sorry, the June email at page 13 of the supplementary bundle?
The 14th of June email.
Yeah. As I stated in the offer letter, the council's duty to your household has been discharged.
Well, first of all, that's wrong, factually, because unless it's said, and it's certainly, as I understand it, has not been Waltham Forest's case, that the refusal was definitively contained in the WhatsApp message, then the refusal can only be a combination of factors. One, that's suggested in the WhatsApp message, but two, when Mrs. Bano the following day, the 15th of June, does not travel to Derby. And indeed, the email of the 14th of June holds open the possibility that despite what's said in the WhatsApp message, Mrs. Bano might still travel to Derby. They're not taking it as a definitive refusal.
That's
because
why I
she
asked the
says if
question.
you are not accepting the offer.
That's why I asked the question, because it seems to be quite similar to the language that you said was more generous than one is one commonly sees today. I was struggling to see the difference.
Well,
The council in Warby, if that's the right pronunciation,
it is, yes.
said, emphasised.
Your client.
My clients, yes.
Your
Yes,
client,
can we
remember how to pronounce it.
Well, also, can we take the opportunity, congratulating you a quarter of a century on your the results
Well,
of that?
I'm not sure how to take that, my lord, but yes.
Anyway, Lord Justice Chadwick, I know that's how you pronounce his name.
Yes.
Who appears to have given judgment on the day.
Yes, he did.
He recognised that, well, he took the view that this language was clear enough in stating that the council was intending to treat the refusal of accommodation as a ground for bringing the duty to an end. The language was, the council is of the opinion that the offer is suitable for you and your household, and by making it to you, the duty accepted towards you has been fully discharged. I'm just looking for help on why our case is different, as to whether there's been a decision.
I'm being helped. Thank you,
Sure.
my lord. What the judge thought, and my learned junior will find the place in the judgment, is that this is not an extra decision because it clearly refers to repeating the offer letter by starting, as I stated in the offer letter, the council's duty to your household has been discharged, whether you accept the offer or not. And the offer letter, of course, talks about will discharge our offer, if one goes back to page 5. So we've talked a lot about practicalities. One of the practicalities of this, besides being sent on a Sunday, is that this is an all credit to her working on a Sunday. But this is an informal response. In response to the WhatsApp message, she calls it a text, and it's urging the family not to refuse. And I appreciate that the tense used is has been discharged, the present tense. As of the 11th of June, it was will be discharged. But the council's subsequent position was not that the refusal was definitively contained in the WhatsApp message. The council's subsequent position was that the refusal was the council's subsequent position seems to have been that the refusal was a combination of the WhatsApp and not travelling to Derby, and the judgment. Yes, I've got it. The judgment is at page 75, and the defendant did not, paragraph 62, the defendant did not submit that this communication was one of the two decisions to end the main duty. It was thus simply a reiteration of the original offer to Ms. Bano's daughter, who was then 15 years old. She'd requested that it be sent by email. This email was in response to that request. In any event, it predated the refusal of the offer on the 15th of June, and so cannot have reached the status of a termination as per the Norton sequence. It also stated that the duty was at an end whether you accept the offer or not. This cannot be therefore a balanced and rational decision based on what the response to the offer is, since it was unknown at that point. The 14th of June email, rather than be an effective decision, was another notice of intention. No doubt for that reason that the defendant in oral argument did not seek to persuade the court that this could count as one of the trigger dates for time to start running as a challengeable decision, simply a reiteration of the original offer and prospective attention, and forcing the submission of Mr. Marshall Williams, who sits behind me, that it is not a decision. How could you review the decision in that email? And it is hard to see how Mrs. Bano, again, if one assumes that she's being advised and so forth, rather than position that she actually is in, receives that email of the 14th of June and realises that she has a right to request a review, that the decision has come to an end under section 2021B. Mr. Marshall Williams put it pithily, and it's quoted in the judgment, so I rely on him behind me. Mr. Mullins, in his skeleton, makes the point that Warsami was only concerned with the jurisdiction to hear the 204 appeal. I've made the point that it wasn't. It was really concerned with the decision about whether or not there was a right to request a review. And Mr. Mullins also said that the iteration of section 1937, which was being considered at the time, has subsequently been amended, and that there is reference in that to notification. I can make a number of points to that, but actually the point is completely answered in Ravichandran, and that gives me a chance to move on to Ravichandran.
Just before you do,
Thank you.
I was just noticing the very end of Wasami, Lord Justice Chadwick's judgment, the paragraph I hadn't looked at before. This is page 248. And he adds a qualification, and he says in the third sentence, it may be that the circumstances in which they left fall within section 1936, in particular within paragraph B, becoming homeless intentionally from the accommodation, or paragraph D, voluntarily ceasing to occupy, if that be the case, so that the duty on the local authority has ceased by reason of section 1936.
I'm sorry, I can't find you.
Sorry, it's the last paragraph of Lord Justice Chadwick's judgment, 248.
Oh, the very last one.
Yes. So
Because they'd left.
exactly. So he seems to be contemplating that the duty comes to an end automatically
Under 6.
under 6, including where there's becoming homeless intentionally, which can certainly be a contested matter.
If that was more than a throwaway remark, it was certainly obiter. It wasn't. There was no discussion of that,
And to be clear, you say that's wrong.
and it would be wrong. Yes, and he hadn't heard argument on that. And I say it's wrong because if you look at all of the different subsections in 193, 5, 6, 7 and 7A, in all of those, there are evaluative judgments to be made. And actually, just before I go on to Ravichandran, because that will take a little time, let me mention Diegi, Tower Hamlets and Diegi, that one I have difficulty pronouncing, Diegi, which is under subsection 6, and it's under subsection 6A, and it's where somebody potentially, the duty might have ceased to be owed because she was no longer eligible. It's tab 11, but I can explain it, and I can take your lordships to the relevant point. There was a complicated set of facts in Tower Hamlets and Diegi. When she first applied as homeless, Tower Hamlets decided that she was not eligible, which, as my lords know, is about immigration status and is fiendishly complicated. And she successfully appealed that decision to the county court. Tower Hamlets were required to take the decision again. They failed to do so. So she went back to the county court. And the county court judge made a decision, including varying the original decision, that she was eligible. By that time, there was no doubt that she'd become ineligible, to add to the confusion. And so one of the points that Tower Hamlets were making, which had been about the judge's jurisdiction to continue to hear the appeal, was that it was entirely academic, because if a section 193 duty was owed, then it would cease to be owed because she was ineligible. And Lord Justice May says at page 262, and it is obiter because it's, by that point, it's a very theoretical scenario. By that point, Tower Hamlets had not accepted that she was owed a section 193 duty. But Lord Justice May says at the top of page 262, having set out previously the circumstances have changed, section 1936A may theoretically not even require a decision, because obviously whether or not you're eligible for assistance seems to be a decision that has the fewest number of evaluative judgments in it. It's overwhelmingly a matter of immigration law. Although no doubt the local housing authority in practice needs to communicate its view, and section 202(1)A seems to contemplate a decision. Section 1936A does not, it seems, give the authority a discretion. You can't decide that somebody is no longer eligible but will continue to owe you a 193 duty. If you're not eligible, the duty must cease. But then, although there may well be a dispute as to whether an applicant has ceased to be eligible for assistance, once the authority has communicated its view or decision, Mrs. Diegi was entitled to request a review, thereafter to appeal if dissatisfied, the continued theoretical existence of the previous decision would have made no difference to any of that. That is obiter, but I just make the point that of all the circumstances in which the duty at 193 could cease, eligibility seems to be that involves the least or the fewest evaluative judgments. And even in that case, Lord Justice May's view was that there may be a dispute, because in fact there may be something to decide factually rather than legally, and therefore, given that there may be a dispute, the authority has to communicate its view or decision, and a request is permitted under section 2021A, which refers to eligibility. So I say every element, all the different subsections, 5, 6, the elements of 6, 7, 7A, all of them require some form of evaluative judgment to be taken at some point as to whether the particular elements whereby the duty ceases have to are met, and that involves an evaluative judgment means a decision. It is a decision that an applicant is entitled to request a review of under Wasami and Ravichenko, which I'm coming to, and therefore they have to take a decision. Can I turn to Ravichenko? It's tab 14. And Ravichandran is another one where there was a final offer of Part 6 accommodation, so it's section 1937. And there are two important points about Ravichandran. The first is Lewisham's position in the Court of Appeal, and indeed Mrs. Ravichandran's position in the Court of Appeal, which the Court of Appeal, Lord Justice Stanley Burton, said were both misconceived. And we see that at paragraph 30, page 30, paragraph 30, page 300. In our judgment, both Mr. Arden's submission as well as Mr. Latham's perceived need to address it by arguing for an implied notification provision are misconceived in view of the analysis and decision of the Court of Appeal in Waltham. What Mr. Arden QC had submitted, bottom of page 299, at paragraph 28, is that in consequence of the amendments to the 1996 Act by the 2002 Act, which is the removal of the word notify in subsection 7, the only decision of an authority as to the discharge of its duty under section 1937, in relation to which a review is possible under section 202, is the decision prior to the making of the offer that the offer will satisfy the requirements of section 1937F, and the refusal of it will result in a discharge under section 1937. And at the bottom of 299, the iteration of 193 in Wasami is quoted, and what was subsequently repealed in the 2002 Act is notify him accordingly within 21 days of the refusal. So Ravichandra is dealing with the version of section 193 that we're dealing with, and with that repealed. At the top of page 300, Mr. Arden, relying on the amendments, and in particular the omission of the notification provision, submitted that section 1937 now provides for automatic cessation of the authority's duty if the circumstances specified there have occurred. The decision, he said, is no longer dependent on any decision to be taken by the authority following the refusal of the offer, and he dismisses as misconceived his own client's actions, who had accepted a review of the discharge of duty decision. And then Mr. Latham, for Mr. and Mrs. Ravichandran, said that it was implicit that following refusal of an offer, the authority must notify the applicant the authority regards self-discharge of the duty. And as I say, both of those, Lord Justice Stanley Burton said both of those were misconceived. He goes through Waltham and over the page at page 301, paragraph 31, he rejects the submission that the amendment has made a difference. Although that was a decision under the unamended provisions of section 1937, the decision remains applicable to the amended provision. Although worded differently, the original provisions of section 1937 provided for automatic cessation, albeit at a later date, i.e. after notification. And he takes the point, he says that Lewisham did comply with that. They did make a decision and they had a review. Mr. Arden submitted at paragraph 32 this produced...
Just before...
Sorry.
One might say, looking at paragraph 31, that Lord Justice Stanley Burton was proceeding on the basis that there had been an automatic discharge. But, well, you can anyway have a review of a confirmatory decision.
The effect of Waltham's case is that its decision taken then, even if only confirmatory of a prior automatic discharge, was reviewable. So the scenario then, if we apply it to the facts of our case, would be that most of the elements of 7AA are set out in the offer letter of the 11th of June, which we know is the case. And then there is with the exception of the Norton point, and then there is a confirmatory decision at some point fairly soon after the 15th.
You might say there is no confirmatory decision, but at any rate, one might get from this that Lord Justice Stanley Burton is contemplating that both under the new legislation and under the Wasami version, there was automatic discharge, albeit that you could have a confirmatory decision.
Whether a decision is a fresh decision or confirmatory, I'm wondering whether that matters. What matters is that there is a decision which happens post-offer, post-refusal or acceptance. Even if it says most of the matters that I'm required to be satisfied about in section 7AA were set out in somebody's previous letter, and I confirm, and I'm aware that Lord Justice Warby was kind of making this point with the email of 14th of June, but I now confirm you've accepted, you've refused, and therefore the duty has ceased. There still has to be a decision that has happened. Even if it's confirming something automatic, there has to be something recorded. I'm hesitating to say something put in writing because of my notification difficulty, but there has to be the local authority confirming or recording that all of the elements of 7AA have been met. So maybe it happens automatically, as it were, in the ether, but it still has to be confirmed. And that confirmation brings a right to request a review. That's not my principal submission. It creates difficulties because, of course, if it happens automatically and is then confirmed 4 or 5 weeks later, you have a period when the duty is not owed, but nobody knows that, and that would cause real difficulties. We say, despite words such as confirmatory, that there has to be a subsequent decision that the elements are met, subsequent to refusal or acceptance, which can, of course, refer to an earlier decision setting out most of the elements. Mr. Arden says this would produce an absurd result because it would mean that it would never be possible for suitability. What was then reasonableness? That's no longer in section 193. It's only in it insofar as there is a reference to contractual obligations. That's and discharge to be reviewed at the same time, we do not accept that criticism. If following the make of the offer by Lewisham, or at any event once there had been a refusal of the offer, there had been a review at the same time of both the suitability and reasonable to accept requirements, as well as the decision prospectively to discharge by the making of the offer, or if after refusal the conditions for discharge had been satisfied, they could have been dealt with at the same time by virtue of section 2022, would not be open for further review. The problem in the present case is that until January 2009, which is the date when the decision that the duty had come to an end was made, it's at the bottom of page 292. There was, the offer had been some months earlier. I can't immediately see the date of the offer, but it was some considerable time before January 2009, because it was refused in October 2008. Until January 2009, there was never an invitation for review of the reasonable to accept aspect or of the prospective discharge of duty by the making of the offer, or of the satisfaction of the conditions for discharge under section 1937, and no such review was in fact carried out until then. The only review was of suitability under section 2021F, and not, as indicated in Waltham's case, under section 2021B, both as to the discharge of Lewisham's duty and the reasonable to accept issue. And that's what my learned friend relies on when he says that there can be a review of a prospective discharge. And I say two things to that. My primary submission is that is wrong. And that is not what Lord Justice Stanley Burton was grappling with. He was grappling with the automatic cessation point, which he said was misconceived. And that in fact there has to be a decision post all the events. But if I'm wrong about that, and if an offer letter, as of our 11th of June letter, can provide for two reviews, one of the suitability and the other of the other elements of 7AA, then Lord Justice Stanley Burton is very clear. There has to be an invitation for a review of the aspects other than suitability, including the prospective discharge of duty. And he says the only review was on suitability under section 2021F, and that's the case that's the facts in our case, because the only review offered in the 11th of June letter is on suitability under, they've wrongly put it as 2021F, it should have been G, but it's the same point. And there is no review offered of the elements of 1937AA. And to come back to Lord Justice Warby's point of, well, does the 14th of June help with that? The review is still not offered.
Can you just help me? I'm being a bit thick here. I can see what Lord Justice Stanley Burton says about there being a problem, because that there was no invitation for a review. But I failed to follow his reasoning. Has he identified a statutory provision that says that? Or has he said that it's, as a matter of public law, it's unfair to proceed without a review, or what? I just haven't spotted what the logic of that was.
The logic of it is, he says in the last part of that sentence is Wasami, and having summarised Wasami and quoted Lord Justice Chadwick and found that the review applies under 2021B, as we know, that's how he gets there to the invitation. I see the point that possibly the notion of an invitation is a leap. I see that point.
Well, that's the only point I really was struggling with.
But he's clear that there is a review available under Wasami, under 2021B. And so he's
right.
saying it has to be, there has to be some sort of invitation of it for it. Otherwise it's meaningless. If one goes back to first principles, if somebody is never told that she could have a review.
Well, There are many contexts in which people have appeal rights. They don't have to be spelled out. So, anyway, I see the point. He derives it from Warsami.
Yes,
is your
he
answer.
derives it from Warsami, and he then goes on and looks at what actually happened. And then, of course, the second point that's being argued about in Ravichandra, which I can just summarise, is the degree to which that results in 2 repetitious reviews. Lord Justice Stanley Burton, Court of Appeal, are very clear that if there is a review on suitability, which might possibly also involve reasonable to accept, and if you accept my learned friend's submission, might include a prospective discharge of duty under section 2121F. I say it's hard to see how that is met, but if you accept his submission, once that review has happened, if there is a subsequent review under B, the reviewing officer doesn't need to reconsider those matters that have already been considered unless there's new information and so forth. So the point about repetition and, as it were, good administration is made. I want briefly to just mention Nicolave and Redbridge, which my learned friend mentioned. It's tab 18. And that is an example, I say, of exactly the sort of dispute that might arise under an evaluative judgment, and why you do need the availability of 2021B, the request for review about whether the elements of 7AA have been made out. And what happened there was, in terms of procedure, was absolutely right. Miss Nicolave, as my learned friend said, wrote a somewhat ambiguous letter that was construed as a refusal. There is again, it's Redbridge did the 2 decisions. They made an offer, they subsequently made a decision in which they characterised her ambiguous letter as a refusal. She requested a review of that duty ending decision, and the reviewing officer looked at it again and decided that it was a refusal, and her appeal on a point of law to the county court, first to His Honour Judge Luber and then subsequently here, was the extent to which the review officer was wrong in law to characterise it as a refusal. But what that shows us is that there could be a dispute between the parties about something other than suitability, and that the right way to resolve that dispute is not through judicial review, but through the simple and appropriate process of the review, which provides a factual reconsideration. That's the best way to make decisions. I have, and my lords have been taken extensively to Norton and Haringey, but I do just want to make the point about what my Lord Peter Jackson was referring to as lawful and unlawful decisions, and that's tab 20. And my lords know what Norton says about the having to explain the full impact of section 195A, including subsection 2. And again, in Norton and Haringey, Haringey did what we say is the right thing to do. They made an offer, they subsequently made a decision that the duty had come to an end. And Lady Justice Elizabeth Lang...
Sorry, just looking at the head note at the moment and just trying to get the facts.
Yes, it was a private rented sector offer. So it's the closest one to us, my lord. And it was accepted.
Well, the local authority accepted the main housing duty, made a private sector rental offer, which she accepted, but she sought a review
Yes.
And the review decision upheld the original decision that the main housing duty had been met. Is that it?
Yes.
She then appealed against that decision, and the judge dismissed the appeal.
Yes. So the details are at page 403 onwards.
And the basis for the appeal was the 7AB, 7AA issues.
Well, it's page 404. The decision of the 27th of January 2021, decision 1, that's the council's decision that the duty had ended. And that, not least because Mr. Norton had accepted the offer. And then there are representations made on review at the bottom of page 404. And there were...
But we're immediately sort of off on a different track here, aren't we? Because here we have a review. I mean, per Norton, the offer wasn't legally correct because, as it turns out, it didn't, not meaning this disparagingly, but tick all the boxes.
So it was only known that the decision was not the offer was not legally correct once the matter came to this court and Court of
Yes,
Appeal.
but it doesn't matter. It was
no,
and always had been not legally correct.
Yeah, that's right. So the conclusion of Elizabeth Justice Lang is page 409. At paragraph 50, on the facts of this case, section 1937F and 8 were a bar to the approval of the PRSO on the 8th of January. The council could not be satisfied that the property was suitable and that section 193A did not apply. So those are grounds B and C, which we were what's now known as the Norton Point as ground A. The council's purported approval of the PRSO on that date was null and void. We know at the previous page 408, under the heading discussion, and it's ground A that is the Norton Point. And Lady Justice Elizabeth Lang says, Section 193 imposes a series of what may seem to be rather technical requirements on a local housing authority. They are, however, the requirements which Parliament has imposed on local housing authorities in order to protect the statutory rights of people who are or may be homeless. Those rights are or may be affected by actions taken by a local housing authority under Section 193. If the local housing authority is to bring the duty imposed by Section 1932 to an end, those requirements must be complied with. And I refer to those in order to support the point I was making to my Lord Peter Jackson about why they do have to make lawful decisions. They have to comply. And then paragraph 43 is where they find that section 195A subsection 2 should have been explained, and we see I would therefore allow the appeal on ground A. Over the page at relief, page 409, the local authorities submissions at paragraph 48, Mr. Grundy, at C, he accepted that if the appeal were allowed on ground A, the failure to comply fully with 7AB little c could not be put right. And so the conclusion is that the council had erred in law in decision 1 in concluding that A had been informed of the matters described in section 71937AB. It follows that the council erred in law in concluding that the offer made in the letter of the 8th of January 2021 and accepted by A ended the duty imposed by section 1932. And Lord Justice Males, I'm grateful, who agrees, adds that paragraphs 55 and 56 and explains why subsection 2 of section 195A matters, and says at page 412, this appeal illustrates what is already well known. Housing law can be highly complex. More specifically, it demonstrates that local authorities who wish to discharge their housing duty by the provision of an assured short-hold tenancy of a private landlord must take care to ensure scrupulous compliance with the terms of section 193 of the 1996 Act. And so I draw my Lord's attention to a couple of points. One is the acceptance of the PRSO, and so people do pursue reviews having accepted, and this is an example. Mr. Norton made a number of points on review, which are fully set out, but we don't need to deal with them. The second is the reference to what seems to be rather technical requirements on a local housing authority imposed by section 193, and the point is made that they are requirements that Parliament has imposed in order to protect the statutory rights of people who are or may be homeless. And my Lord, that deals with authorities, unless there's any other authority that might.
No, thank you.
Can I just make a point about the policy point? And it's my Lord, I've made the point that insofar as a second decision after the offer creates an additional procedural requirement, I say that is a small price for the benefit that it provides, both about the request for review on the whole of the elements that the duty has ceased, and the certainty that would have happened in this case, we say, had that not occurred. I do need to point to, because there is an error in my skeleton. I give you a list in my skeleton of cases where local authorities made two decisions, the offer and the decision. 3 of those were made under subsection 5, and there is no doubt that there has to be the two-stage decision in subsection 5, and they are Osserley, Omar and Bromley and Broderick, on which I think Lord Justice Newey sat, and so I can't rely on those. In relation to the others,
Sorry, so that was
Osserley, Omar and Westminster, Bromley and Broderick.
Yeah.
In relation to the others, of which there are 9, there are actually 7 reported authorities, but 2 of them each deal with 2 sets of cases. Then all the local authorities that are not Waltham Forest operate the 2 decision process, the offer and then the decision that the duty has come to an end. And what is striking is that the 2 that involve Waltham Forest, there's Actor of Waltham Forest, which was reported with Hajaj and Westminster, and there's Zyman and Waltham Forest. They're all about suitability, so that's the substance of the case, but they don't seem to involve 2 decisions. And I did need to correct that from my skeleton. The appellant says that the effect of the Deputy High Court Judge's decision is that floodgates would be open. We say no. 1, because whilst we're not in a position to produce evidence about the practice of local authorities, we do point to the case law as showing that reported cases involving local authorities who are not Waltham Forest do operate the two decision process. And secondly, that what is difficult and unusual about this case precisely arises from the fact that there was not a decision setting out those elements that would have given her a right to request a review. Because had there been, we wouldn't be here now. Either she'd have requested a review, and that would have followed through, or she wouldn't. And the point that the Section 193 duty had not come to an end, had not ceased to exist, would not be taken. And then finally, we set out in the skeleton what references there are in the code, and the code does not specifically say whether there should be one or two decisions. But we give you the paragraphs in the code, and we say that at least one of them, and that's paragraph 15.8, which is at tab 7.
What paragraph in your skeleton argument?
Thank you.
Yes, 67. Sorry, thank you.
Yes, yes,
I
I'm
got that.
grateful.
Thank you very much.
1548 in the paragraph 1548 in the code, which is page 181 in the bundle of authorities, suggests two decisions, we say, because paragraph 1548 says that housing authorities should allow applicants a reasonable period for considering offers of accommodation that will bring the main housing duty to an end. And then there's discussion of what might be a reasonable period, to which the answer is there's no set reasonable period. So we say that suggests two decisions. Those are my submissions on ground 1. And I think my lords have my submissions on ground 2, but none of those that if I'm right and there is no automatic ending, if there is an automatic ending and I lose on ground 1, well then I lose on ground 1. If I'm right on ground 2 and there is no automatic ending, you have my submissions about why none of the letters, including that of the 11th of June up to the 7th of October, are clear and effective about the decision coming.
This is 69 to 77 in your
Yes.
your document. Thank
Yes.
you.
Yes.
Can I just talk around that a moment? Perhaps starting with Mr. Eggbom's witness statement. This is supplemental bundle, paragraph, page 52. So he says Ms. Bano's homeless application was closed, and so on. Now that might be thought to suggest that a decision was made. Do you say that's wrong? Supposing a decision was made, you presumably say, well, it wasn't properly notified, or what?
Well, I say that I can't dispute it was closed. And indeed, that's the whole tenor of some of the correspondence. My lords have my point about the difficulties of a decision that might just be made and certainly it's not notified, but also there is no record. And in the course of the judicial review, of course, the housing file was disclosed and we've looked at it, and there is nothing that one can point to that says this is a decision. And Mr. Mullins will correct me if I'm wrong, but we've read it. But I also point to the whole of the phrase in the brackets in Mr. Eggbom's statement, because he says section 193 duty ended by the offer of PRS, which she refused. So obviously there is a danger of overzealous analysis, but that suggests that certainly the decision of the 11th of June was not in itself a prospective decision that the conditions would cease to exist, that the duty ceases to exist because the conditions are met, because he goes on and refers to the post-offer event, the refusal. So he's certainly saying there that the 11th of June letter is not sufficient. And if he is saying that post-refusal there is a decision, he doesn't point to what it is. You have my submissions on the documents that we have. Mr. Mullins doesn't point to another decision. He doesn't flourish a piece of paper and say, here it is. And so it's hard to see that there was a considered decision by the local authority that the elements at 7AA, etc., were met.
So can I just follow up on that? for one moment longer. Suppose you have a case where a local authority sends an offer letter, much this form, saying whether you accept or refuse, the duty is coming to an end. And subsequently, we'll suppose that there is an acceptance or a refusal. But we suppose further that in subsequent correspondence, the local authority refers in terms to the duty having come to an end. But let's suppose it didn't, so to speak, decide that, it just thought that had happened. It's just recording what it sees as the consequence of the offer and the refusal. Is there a decision, as you would see it?
That seems to be what's happened in this case, because the letters, the 7th of October
Yes.
and so forth, don't say this is a decision. They record that, and that's what Mr. Edwards says. It's hard to see how there can be, because, as my lord made the point, the subsequent records are records that something has happened. They're not a decision. And the earlier records, the offer and so forth, are not in themselves a decision. And if my learned friend is right about this concept of prospective decision, which we don't agree with, then even if they're a prospective decision, then there isn't a decision about the post-offer events.
And one final follow-up. Might that open up all sorts of things that we haven't thought about? Because, I don't know, there may be lots of local authorities that don't think they need to make a further decision. They merely think that they have to recognise what, so far as they're concerned, has happened as a matter of law, even if they record it in writing. And on your case, in that situation, the duty would just continue, even now.
Well, I say that would be very concerning, because I say local authorities, they're legally advised, they undergo training. It's part 7 is self-contained, very much stands on its own, and it's the point that Lady Justice Elizabeth Lang made, that local authorities must be complying with the statutory requirements, however arid or technical, and that's Lord Justice Males's comment, however arid or technical it may seem. And they should be. And I say it would be shocking if routinely they haven't been.
But
and there isn't any evidence to
No, I see
effect.
that.
The acceptance point in Norton, there was a decision that the duty had come to an end as a result of acceptance. I say it would be dangerous to predicate that is the case. What is less dangerous is concluding that even if local authorities were too often taking a slightly haphazard approach to Section 7AA, particularly if they thought they were not going to be challenged because of acceptance and so forth, to conclude that they should not nevertheless comply with what I say are very clear statutory requirements that involve decisions and evaluative judgments, is potentially a recipe for chaos for both applicants and local authorities. And the way to avoid chaos is to make sure that there are proper decisions in accordance with the statute.
Yeah.
And can I finish? I'm just checking. By drawing my Lord's attention to paragraph 45 in the judgment, where the judge says there was forensic debate during the hearing about the technicality of this issue. But in fact, this is about something different, the proper and fair protection of the rights of people who are often vulnerable and who are being supported with their living accommodation. Parliament has therefore set down carefully articulated pathways to ending the main duty. They cannot be ignored, nor should they be trivialised. They exist as a matter of safeguarding fairness and good administration. And I would say that safeguarding fairness and good administration is a benefit, obviously, to those who I represent, Mrs. Bano, and when I represent others, but it is also a benefit to local authorities because it provides for finality of decision making. Would my Lords just give me one moment? Thank you very much, my lord. Unless there's anything else I can help you with.
No, thank you very much indeed, Ms Davis, and also to Ms Marshall-Williams. Yes, is there any reply?
There is one, Lord. I'm hoping very briefly. Towards the end of my letter of friend submissions, there was discussion of paragraphs 31 and 32 of Ravichandran on page 301 of the authorities bundle. I just want to revisit that if I may. In my submission, it is impossible to read paragraph 31, in particular the final sentence of paragraph 31, as anything other than saying the mechanism under section 193 creates an automatic discharge, i.e. that the main duty comes to an end at law by virtue of the act upon the circumstances arriving, rather than on the basis of a decision of the local authority. That must be right in my submission, because what it's talking about is the confirmation of a prior automatic discharge, so a decision that recognises that the duty has come to an end, rather than a decision that ends the duty. And with great respect to the judge below, that is the mistake that the judge makes several times throughout his judgment, is that he confuses those two concepts. And one can see when one looks at section 193, for example, section 193.5, there are circumstances, so the final limb of section 193.5 is that the authority notify the applicant they regard themselves as ceasing to be subject to the duty under this section. So the final step is the decision that they regard themselves as no longer being subject to the duty. In that sense, that it still happens at law, because it still happens by virtue of subsection 5 in the Act, but the final step, the final domino in the chain, is the local authority's decision that it regards itself as no longer being subject to the duty under section 193.5. It's different under section 193.7AA, because the final domino in the chain is the refusal or acceptance of the offer. Necessarily so, because all of the other dominoes, which are set up by section 7AA itself in terms of the matters that have to be informed under section 7AB, and the matters also set out at 7AC, 7F, all necessarily have to take place before the offer is made in order for the offer to be a valid offer. Now, therefore, it's impossible to read paragraph 31 as anything other than recognising that analysis in my submission. Otherwise, there is no prior automatic discharge. I do rely on paragraph 32 as well. I wonder whether the problem identified or the question asked by my Lord Lord Justice Warby in relation to the invitation, I had read that, and I may be wrong, but I had read that as the applicant inviting the local authority to review their decision, rather than the local authority inviting an applicant to seek a review. I wondered if it was a more formal way of saying that there had been no request for a review until that point as to duty.
Well, it's difficult to read it that way in the light of paragraph 35.6, to which you drew attention earlier on page 303.
Yeah. So I accept, and which was my lordship has the point. That was the next the next part of the judgment I was going to take your lordships to. Is I think it is very difficult to see if paragraph, and I think paragraph 35.6 must be part of the ratio, that says in terms that it is possible to seek a 202.1b review before the refusal, i.e. before the duty has come to an end. It will strictly that be a review of the intention that the offer will, on refusal, result in cessation of the authority's duty. That again reflects the automatic nature of it, and you're entitled to a review of that decision. Now, it does go on to say, I accept, that the applicant should be informed of the right to such a review. And in my submission, that's exactly what the respondent was informed of. Because whilst there is a specific reference to a section 202.1G review, or I think they may have got it wrong and said 1F, a suitability review, that's because that's one of the preconditions under section 1937AA. They have to be informed of the right to request a review of suitability. That's on page 6. At page 11, it's headed right to review. Housing Act 1996, section 202. It's not limited in any way. And it says, if you wish to request a review, it doesn't say request a review of suitability. You must do so within 21 days. Bearing in mind that there's a lot of authority about reading these documents benevolently, and that they're not supposed to be passing legal exam questions. That, in my submission, that box right at the end of the decision letter, it's perfectly clear there is a right to review under section 202. It doesn't say, there is no authority to say that the local authority has to inform them of their right to review at all in the context of a duty review. I accept that in Ravichandran it's expressed, I think, as being that they should. It doesn't say that if they don't, that's fatal in some way. I think it's a summary of principles to assist in best practice more than setting up a requirement that would make it unlawful. But even if that's right, that would satisfy that requirement at page 11 in my respectful submission. Because it doesn't just say you can have a review of suitability. It says we have a right to request review under that section as a whole, effectively.
If you succeeded under ground 2 on the basis that there was a decision that could have been reviewed at the time but wasn't,
yes,
you don't need ground 1, do you?
My lord, no, I don't, because it would be unnecessary for the court to decide that the right to ground 1. The court wouldn't have to decide whether such a decision is required, whether a confirmatory further decision is required. And I do use the word further in the ground. It was, I hope I've clarified it in the skeleton and oral submissions. What I mean is some future decision or some decision that postdates the refusal, which recognises the cessation of the duty under the terms of the Act. So no, I don't think we do. If we succeed on ground 2, then in my respectful submission, the decision of the judge below must be quashed, and then the court has a decision. I invite the court in my skeleton argument to substitute a decision refusing permission. If the court's not with me on that, then it would have to go back to be reconsidered in my submission.
Could I just be a little clearer in my own mind? What are we meaning by an automatic decision in this case?
Not an automatic decision, so an automatic
Cessation
of the duty.
Yes.
So
I'm sorry, of course.
The duty comes to an end not because the local authority makes a decision. It comes to an end. I say the duty comes to an end where the conditions for cessation
are met in the statute.
Yes.
Right.
And
if the duty has not come to an end because the conditions of the statute are not met.
Yes.
But the duty continues, but you maybe erroneously were to articulate that they had come to an end.
My lord, yes.
You invite us to say that that's a decision in the circumstance of this case that could have been challenged and wasn't.
Yes. Well, what the respondent would challenge was the non-compliance with the failure to provide her with accommodation.
Yeah.
And once it cancelled her temporary accommodation, cancelled the booking, it was no longer providing it to her. It would have been in breach of the section 193 duty. That would be a continuing breach. And
so there's a numbers of activations of a decision.
Yes. The time for judicial review would have started to run when the grounds for challenge first arose. The grounds for challenge first arose when we ceased to be in compliance with the section 193 duty, or said that we were no longer owed the section 193 duty. or communicated that in some way.
So
It wouldn't need to be a
ground
formal-
2 is a much more case specific analysis than ground 1.
I think that's fair to say, my lord. Yes, because in this case, it's very difficult to see how, in my submission, where the local authority write the email of the 14th of June, cancel the temporary accommodation following the expiry of the COVID ban in August, and then in October make clear that the appellant should be making her own arrangements to find somewhere else to live. I mean, it's with great respect completely implausible to think that there was any.
Well, if you reverse it, let's suppose Miss Bano had applied for a review in terms, or issued some sort of an appeal, or launched judicial review. The one thing that she wouldn't have had to face was, one would imagine, is an argument, well, we haven't decided anything.
Yes, no, we would have said, I'm confident we would have said, no, we regard, at that stage, we would have said we regard the main duty as having come to an end in accordance with section 1937AA.
So whether you're right or wrong isn't the point at this stage.
One of the notes I have to reiterate is, I as the court mentioned earlier, there doesn't need to be a lawful, the best decision that could be made. There just needs to be an act or a decision by the local authority otherwise than in accordance with the main housing duty. That would be the ground of challenge, and that's really what that's why I opened the case by saying the judicial review was one that could have been bought in 2020.
Yes, I'm sorry. I don't know whether I interrupted you or whether you had expired.
I haven't quite expired, my lord, yet, but I think I only have another point to make. Yes, it's a difficult point to raise because this court's focus is, again, as I mentioned in my submissions previously, is on the judgment below, and so there's if I can establish that the judge below was wrong in law, then that decision has to be quashed in my submission. I don't. If this was a statutory appeal, because we'd be focusing on the first instance decision of the reviewing officer, there could be a greater opportunity perhaps to make comments about the local authority's procedure and best practice and so on than is necessarily the case in this sort of an appeal. It's a very confused way of saying, I think that really the argument in this court is restricted, certainly from the respondent's point of view, to the arguments they made below and the reasons the judge below gave for his order.
Right, we're not carrying out an encyclopedic review of the whole part of the statute.
No, and as fun as that would be for housing lawyers, it's yes, the respondent, and particularly in the absence of the respondent's notice, is stuck with the arguments they made below and the reasons given by the judge below for his decision. And so some of the discussion in my submission about, and I still don't, I don't think it's accepted that there's a review, that it's possible to seek a review of a prospective intention, i.e. the offer letter. In my submission, that isn't open to the respondent because the judge below finds that was a reviewable decision on suitability on duty specifically. The paragraph is judgment that I took the court to earlier. So it's not open to the respondent really to argue that. And if there was a reviewable decision as to duty in the offer letter, that is the that's a complete answer, as I said before. If the court's satisfied with what I say about page 11 of the supplementary bundle in the offer. If I might turn my back briefly, my lord.
No.
I'm grateful, my lord.
Well, thank you very much indeed. Interesting point, and if I may say so, very well argued. We'll 25 years ago, one of us would have launched into a judgment, but not today.
25 years ago, I had the benefit of Mr. Lubo.
You'll be well aware. We'll let you have our judgments in draft in due course for the opportunity to make editorial corrections and suggestions, and to allow you to draft an agreed draft order if you possibly can, a few paragraphs about any matters of disagreement if they arise, and in due course, of course, you having treated the draft judgment with the confidence that will appear in the front page, it'll be handed down electronically without the need to trouble you for further attendance. All right. Thank you very much indeed.